The court case seems to finally be clearing up, and things could come to an end very soon as Ripple keeps achieving small victories. Will this finally help Ripple win the whole case? And will Ripple be able to reach new all-time highs then? Welcome, XRP Army. Let's grow the XRP Lab community by pressing the like button and subscribe. We are giving away $500 at the end of the month to one random subscriber to continue on their XRP journey. All you need to do is to like the video, subscribe, and comment your thoughts on XRP in the comment section. Hey guys, have you ever heard about Stablepool? If you own XRP and are interested in making constant money on exchanges like 1inch, Uniswap and co., then this website is perfect for you. After having to sign up to the site with your email, you can simply go to Top Up and select the currency and the amount of it that you want to deposit on the site. Now go to Open DeFi Staking or add liquidity in Liquidity Pool. The site shows you how much of that amount you'll earn as interest within 12 hours, usually around 0.1 to 0.2%. Within 1 year, you'll have made 2x without any risk, which helped the site receive more than $80 million within the first week. And the best part, if you sign up until October 31st, you'll receive $50 in a random cryptocurrency for free. In today's video, we'll discuss the new great win for Ripple in the SEC case and the possible upcoming price explosion. Let's head into it. Recently, a Manhattan federal judge ruled that a group of individuals who own digital tokens associated with Ripple Labs Inc. can provide their meaningful perspective in the Securities and Exchange Commission's case accusing the company of violating securities law. The SEC had accused the company of violating securities law. According to U.S. District Judge Analisa Torres, the 6 holders of XRP, the world's 7th largest cryptocurrency by market capitalization, can provide views on key legal matters in the case, which claims the token is an unregistered securities and seeks to have it declared as such. Those who practice law in the cryptocurrency area are keeping a close eye on the case, as authorities continue to struggle with how to regulate the asset class. The SEC has filed lawsuits against certain digital token issuers for selling unregistered securities, while other assets like Bitcoin and Ether have avoided being labeled as such. The holders of XRP tokens filed an intervention request in March, claiming that they were de facto defendants in the case and that they wished to safeguard their interests. On Monday, a request for comment was not immediately returned by John Deaton of the Deaton Law Firm, who represents the XRP holders, or by a representative for the Securities and Exchange Commission. It was announced today that we had all been granted Amicus status. Deaton shared his thoughts on Twitter, where cryptocurrency aficionados reacted positively to the decision. In 2012, the creators of Ripple launched the cryptocurrency XRP. The Securities and Exchange Commission, SEC, filed a lawsuit against the San Francisco-based firm and its current and former senior executives in December, saying that they have been undertaking an unregistered securities sale worth $1.3 billion since the token's inception. According to the firm, XRP has traded and been used as a digital currency since its inception. Ripple and its management have categorically refuted the claims. The holders of XRP, which included Deaton's daughter, Jordan, claimed in their application to intervene in the lawsuit that the token had lost $15 billion in value when cryptocurrency exchanges in the United States, including Coinbase, delisted or halted trading in XRP after the SEC sued. Torres dismissed the XRP holders' request to intervene as a class in the lawsuit, claiming that doing so would cause an unnecessary delay in the proceedings. The SEC had claimed that the token holders should not be allowed to act as amici and provide evidence. Their legal arguments will be limited to matters such as whether or not the lawsuit should be dismissed, according to Torres. Also, make sure to write your thoughts on these news in the comment section. Ripple, luckily, continues to stay active and brings in more and more compelling case material. It has filed a letter opposing the SEC's request to refrain from responding to the over 30,000 requests for admission that have been submitted to the company, RFA. Yes or no inquiries, such as requests for admission, are used to expedite the litigation process since the answers supplied can resolve disputes between parties if both sides agree on the facts. Requests for admission are also used to expedite the litigation process. As a result of spending more than 100 hours responding to only 254 requests, the SEC asserted that responding to RFAs was time-consuming. This takes around 24 minutes to answer a simple yes or no question. The agency wants to be sure it is delivering the correct response because the responses are being given under oath and may be used against them in court. It was pointed out by Ripple's legal team that completing out the RFAs makes the company vulnerable to the SEC, as can be seen in this section of the transcript. The RFAs concern critical facts that defendants believe are not genuinely disputed. Truthful admissions by the SEC will therefore significantly narrow the issues for trial. The SEC does not seriously argue that the RFAs are irrelevant. Instead, it focuses almost exclusively on the sheer number of RFAs to argue that they are unduly burdensome. This is triply wrong. First, as a matter of law, the large number of requests to admit is not in itself a basis for a protective order. The whole transcript can be read online, so be sure to check it out. By the way, what do you think about the success chances of this move? Let us know in the comments section down below. A major victory for XRP holders, the group of individuals the SEC purports to be protecting, has occurred in the background of this decision. XRP holders' petition to intervene in the case was denied by the SEC on the grounds that there was a danger of an avalanche of claims. The decision came after a protracted period of waiting. However, while the judgment by Judge Analisa Torres, who dismissed the request, may be seen as a setback for those seeking to block XRP, the more than 30,000 holders of the cryptocurrency, represented by attorney John Deaton, have seen the decision as a victory. This is due to the fact that the XRP holders were awarded amicus curiae status by the judge's ruling. An individual who is not a party to a lawsuit but who provides information, knowledge, or insight that has an impact on the problems in the case is granted the status of friend of the court, which comes from the Latin phrase meaning friend of the court. Movants will be permitted to act as amici curiae in this action in their individual capacities, the court rules. The order said that, as a result, Movants shall be permitted to assist the court by presenting legal matters pertinent to the case that have been approved by the court in advance. It is anticipated that such assistance will be most useful during the briefing phase of dispositive motions. Nevertheless, the court retains the right to seek or refuse further applications as it sees fit. I liked this official finding by the judge, that XRP holders and Ripple have a common interest, because it's a concession by the judge that a ruling against Ripple is a ruling against all owners of XRP, said Jeremy Hogan, an XRP community-friendly attorney, in response to the ruling. Mr. Deaton submitted his request to intervene in the case in March, but it wasn't until October that the decision was made public. Meanwhile, he has maintained his prominence in the cryptocurrency community, providing guidance to investors on how to navigate the lawsuit and attempting to garner mainstream media attention for what has been dubbed the cryptocurrency trial of the century, through a recently launched blog, which was also utilized to draw attention to the alleged conflict of interest surrounding the XRP lawsuit. What impact will this have on the price of XRP? XRP has been trading above $1 for more than 5 days now, with the cryptocurrency valued at $1.06 at press time, representing a rise of 13% over the previous week. While the growth appears to be satisfactory, XRP's trajectory in comparison to the wider market may be considered sluggish. While the XRP ecosystem has been a tense environment as a result of the SEC versus Ripple Labs case, XRP recently received some much-needed social recognition when XRPL Labs revealed that offline payments may soon be available on XRPL. The proof of payments protocol, which the business is developing, was also unveiled by the company. This has the potential to spur future retail adoption. Its ramifications were seen in the market, as XRP's metrics began to trend in an extremely positive direction. This combined with the positive court news should be able to give XRP a huge pump, if not now, then after the case is finally settled and XRP should be able to reach new highs of above $3. What do you think about the petition? Do you think it will be the final winner for Ripple? Let us know in the comment section. If you want to continue knowing about XRP, we have 2 more videos waiting for you on the end screen to check out. Enjoy your day and I'll see you in the next video. Before heading out, kindly note that prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice. You should not treat any of the content as such. The content in this video is for educational purposes only and hence should not be considered as financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions.